Well, good afternoon. Welcome to this teleseminar on prenuptial agreements, whether you should get one or why you should get one. Um, I've been doing prenups through most of my career. I've been very selective in how I do prenups. Most of the time people ask, do you need a prenup? Why do I need a prenup? And I thought I'd try to answer those questions in a brief summation this afternoon um, to clarify some things. Obviously, I'm not going to get to every single aspect of what goes into a premarital agreement, but I can at least address some preliminary um, issues that come up. Probably the most important thing in a prenuptial agreement, no matter what happens to the marriage in the event it ends in divorce or separation, is the prenup allows both parties to identify, disclose, and characterize assets and debts that they're bringing into the marriage, liabilities, any kind of property they have, what perhaps if they're anticipating some sort of inheritance, they can identify and characterize that at the outset of their marriage, so everybody knows what they're coming into the marriage with. It's critical in that process that there be valuation, and that both parties have a right to further investigation if necessary to determine the validity of the information, corroborate, support, verify information that the other parties providing as they go into their marriage. Now, it's always a tricky topic for people to talk about in uh, the engagement period. Everyone wants to be happy and certainly looking forward to a beautiful event, and it is a beautiful event. But the realities are there. Many times I work with people who've been through the pain of divorce, the agony of trying to figure out what is going to happen to their finances. And a prenuptial agreement allows the parties to not necessarily anticipate divorce, but at least be prepared in the event something happens and the marriage ends, to establish what their financial picture is going to look like after they finish their marriage, if their marriage ends. Uh, Not only does the prenuptial agreement enable you to identify those things that you have bringing into the marriage, but also allows the parties to opt out either fully or partially from the community property system and characterize their income and assets as they live their married lives. So what they bring into the marriage remains their separate property, but anything they earn during their marriage is presumptively community. The law assumes it's community property if you earn it or acquire it or you borrow money during the marriage. It's community assets, a community liability. The prenuptial agreement allows you in the body of your contract to contract out of that presumption and to allow you to keep your income as separate property, keep your assets as separate property, even if you earn them during the marriage. Very important factor. And that's typically why people opt for prenuptial agreements, is to ensure that any monies, anything they earn during the marriage, or any labor that they put into perhaps a premarital business is precluded from being considered part of the community. And that's very important. That's probably a primary reason why most people would get a prenuptial agreement. You can also identify spousal support, alimony. That's another critical thing that needs to be addressed in the prenup. Too often I see people do a prenuptial agreement, and what they end up doing is addressing their premarital assets. They address any possible inheritance they get, but they don't deal with spousal support. And in a prenuptial agreement, both parties can either waive spousal support or contract in a way that limits the amount of support that would be paid from one party to the other. And that's important, because even if your assets remain separate property, any income that you earn from those separate property assets is fair game for the economically less economically weaker spouse in the divorce to obtain support from the other party. For example, the parties get divorced, and at the beginning of the divorce, one party is out of work, or they're disabled, or something along those lines happens, and they need support from the other spouse. Um, Even if your assets are in the prenup allocated to separate property, the income from those assets may be used to determine how much support they pay to the other party. So if you're going to deal with a prenup, it makes no sense to do a prenup that only addresses your premarital property, that only addresses how income's going to be characterized during the marriage without addressing spousal support. So I think anybody who does a prenup without addressing spousal support in the prenup is making a huge error and might as well not even get a prenup, because it doesn't protect you from having to disclose that information in your divorce, even if everything's separate property, even if everything's contracted out and you're keeping what you came into the marriage with. You still have support, you still have spouse support, you still have a duty to support your spouse, and that can be considered and discovered in the divorce. So bear in mind, don't do a partial prenup. If you're going to go about this, one other thing, you're not going to be able to address anything about children, either child custody or child support, in a prenuptial agreement. Prenuptial agreements are an instrument of dealing with money issues. So if you're going to be dealing with child custody issues in a prenup or child support, you're not going to be able to do it. It won't be enforceable in the divorce or legal separation. So that's another factor to consider. Going forward, you get the prenup. How do you address it? How do you deal with it? Do both parties need lawyers? My answer to that question is yes. Now, someone may tell you differently and say, well, in certain situations, if one party doesn't want to get a lawyer, the prenup is still valid. There's an old saying, just because you can doesn't mean you should. And I don't recommend anyone get a prenup if they need it to have a prenup and they feel it's in their best interest to not have the other party represented by an attorney. I know it sounds like I'm promoting the employment of lawyers, and you can be cynical about that, but the reality is the money you spend ensuring that both parties have an attorney drafting this agreement is money you're going to save down the road. It's a good investment, and having litigated prenuptial agreements, I think it's a wise investment. Don't wait till the last minute. Don't decide to do this the week before the wedding. Not a good idea. Make sure you get your prenup done before you get your invitations out. It's an old rule of thumb if you can do it. If not, at least allow 60 days from the time you decide to retain counsel to draft the prenup and the date of your wedding, to enable both parties to have lawyers, the agreement to get drafted, reviewed by the the spouse who asked it to be drafted. Make sure it gets sent over to counsel, directly to counsel, and that counsel and their client review it, and they are able to get back negotiated terms. Anything that's negotiated between the parties in a prenup must be documented. Don't try doing verbal agreements. Too often I hear situations where the spouse who's doesn't benefit from the prenup, the one who's the weaker spouse, let's say, the one who came in with less assets, says to me, oh, I was told it was just a formality and that's why I signed it. That's not the way you want to operate in this situation. Make sure anything that's stated, reviewed, any terms that are changed, any terms that are requested to be changed are documented somewhere in a transaction between the lawyers, so that when the agreement's finally signed and subject to and enforced later in the divorce, that everybody knows what was done in drafting the agreement, and there's a clear record of how the agreement was put together in case one party decides to challenge it. Perhaps one of the things that comes up when you actually sign the agreement is, how do we document the signing? Well, usually it's notarized. Both parties should have signatures notarized. If the resources or the assets involved in the prenuptial agreement justify it, make sure the signing is videotaped, and make sure each party is asked questions to make sure that they understand what they're signing, that they're signing of their own free will, and that they've talked to counsel about what's involved in the agreement, and they understand the agreement impacts their community property rights in the state of California. One last thing that I need to note, well, I keep saying last thing, it may not be the last thing, but make sure you know which law applies in your prenup, because not everyone stays in the same place they got married in, and certainly not in the same place where their prenup was drafted. If the parties decide to move out of state, and the agreement in the prenuptial agreement states specifically that the law of the state of California will apply, then even if you go to out of state, let's say Colorado, Texas, Florida, those state courts would have to apply the California law in interpreting the prenuptial agreement. So make sure you understand that going into any sort of a situation where you either work with a party who is doing a prenup or you're getting a prenup yourself. So certainly if you have any more thoughts on this or questions, you can send your questions to myself at dgold@tldlaw.com. Again, that's DGOLD at tomlarrydavidlaw.com. I hope you've enjoyed this presentation today. And if you decide to get married in the future, congratulations. Think about a prenup.